Hi everyone, my name is Andrea Chavaria and I'm an immigration attorney. Today I am going to talk about immigrant visas and what to expect at the interview and what could cause a delay or a denial in your case. So I'm going to go through this list, and first of all, I'm going to talk about the medical exam. So when someone has to go to their appointment for an immigrant visa is just another way of saying lawful permanent residency or green card, but you have to go to a authorized medical clinic to get basically a medical exam done. And at that medical exam, the doctor is going to make sure the reason you need to go is to ensure that you don't have certain diseases such as tuberculosis or syphilis, which could affect, have a disease that could affect the public. They want to make sure that you don't have that. If you do, then you do have to undergo treatment before they can complete the medical exam. So oftentimes not oftentimes, but we do see in certain cases sometimes that there is a false positive reaction to tuberculosis, and we have seen delays in those cases. Clients will have to get an x-ray and then they'll get placed under treatment. Now, depending where the interview takes place, which country, sometimes some of our clients have been out approximately 6 or 8 weeks while they finish treatment, and then they go back to the medical exam to complete it and then proceed with their interview. Now, another thing at the medical clinic that they're looking for is to make sure that the person does not have any drug issues, such as being a drug addict, using drugs that are not prescribed to you, or if they believe the person is an alcoholic. And this is very important because one of the things that we've seen sometimes is here in the United States, certain states have legalized marijuana, but at a federal level, it's still illegal. And sometimes people don't know that, and they travel abroad to their immigration interview. They go to the medical examiner's office to get their medical exam done, and they get flagged for use of marijuana. So that's extremely important to know. And also, like I said, they are gonna generally drug test you. And I did have a situation where a client was super nervous and a family member gave them an anxiety pill, was not prescribed to them. They went to the interview they went to the medical examiner's office, and it came up and they got questioned about it. So it's very important to know what to expect when you go to the medical examiner's office. That medical doctor is not your personal doctor. That is a doctor that is contracted by the US government. So whatever you tell that doctor, they are authorized to tell that information or relay that information to the US government. So again, very important. If you have had any history with DWIs or drug usage, you need to consult with an immigration attorney, because we do see situations where the individual doesn't know, they start talking to the doctor and they get flagged and they get denied. And some of these denials can be permanent denials. Okay, so another thing that we often see is issues where there's a denial is if the person has certain criminal history or certain tattoos. And again, this is all going to depend on where you're doing your interview. So this we normally see in Mexico or Latin American countries. If the person has tattoos, they are actually at the medical examiner's office, they are going to notate the tattoos that the person has, what the tattoo is, and they may ask, what does your tattoo mean? If the tattoo looks like it might actually be related to a criminal organization, whether it's a gang or a drug cartel or other criminal organization, then at that point the case can get denied, and that can lead to a permanent denial. So if you have tattoos and you're thinking of going abroad for your immigration interview, it's very important to consult with an immigration attorney. Usually what I tell my clients is, please send me photos of those tattoos, so we can look at the FBI list, look at the gang tattoos, and see if maybe it could potentially seem like it's related to a criminal organization, and let the client know about the potential risk there. And the other thing would be, like I said, criminal history. So certain criminal history where it suggests that there is some sort of gang association, that likewise can lead to a permanent denial. If you've ever been arrested, if you've ever been arrested and maybe the arrest was part of the arrest dealt with the police department that was the gang unit. Well, we want to see those documents because we want to see, will that affect you if you go abroad to your immigrant interview? Extremely important because, again, some of these cases, the clients are living in the US and they're traveling abroad for their interview, and the last thing we want is for that client to get permanently denied and get stuck abroad. I'd already mentioned this, but if you test positive for a communicable disease, so again, they're looking at tuberculosis, syphilis, clients who, or potential clients who have HIV or AIDS. This used to be a really big issue back in the day where a waiver was required. A waiver is no longer required, but what we have seen with certain individuals who do have AIDS or HIV is sometimes they'll get a positive reaction for tuberculosis. And so again, that's going to delay your case because you have to go under certain treatment, and they won't let you go past, won't let you normally attend your interview until that medical exam is done. So if that's your situation, again, important to consult. Not all of the cases, like I said, will get denied when we're talking about immigrant visas, but there are situations where either certain cases can lead to a permanent denial or it can lead to a delay. And we've had situations where cases have been delayed, and it's been delayed by weeks or months. And you know, we like to have our clients prepared and let them know this could potentially happen because it freaks them out, it freaks their family members out, especially the ones that are here abroad. And so we want to make sure that clients are prepared of what could potentially happen when they attend their interview. Now, another situation where we can see a delay is if you do not provide sufficient evidence or you have missing documents. And for the missing documents, the way it normally works is, let's say you forgot to take your spouse's US birth certificate, or you forgot your criminal clearance letter if it's required at the embassy or consulate. Well, normally what they'll tell you is, okay, well, you've been denied, and you haven't been denied, but they'll give you a sheet and they'll tell you you need to submit X document in order for the embassy or consulate to proceed and adjudicate the case. So that's not a denial, but it is a delay. And what normally happens is you can't just grab the document, show up at the embassy or consulate store and say, hey, I have the document, here it is. The way it normally works is once you get that document, you have to print out this document through their portal, and you go to the recommended courier service, which is normally DHL. You go to that designated DHL location, you send it over to the embassy or consulate, they receive it, then they process it, and then they'll issue the visa. So unfortunately, if there is a missing document, it's not as easy as just running back to, let's say, your hotel, or grabbing it from the government office and then just trying to go back to the embassy or consulate and submitting it. There are steps to it. Another issue that we often see with consults where there's been a denial is when the person has a permanent bar. And a permanent bar, there are two ways that you can get a permanent bar. And permanent bar went into existence or into law on April 1st, 1997. And this is a very important date. So basically the law says if anyone has been ordered removed, deported from the United States, they attempt to re-enter or they re-enter the United States without authorization, that person has a permanent bar. The other part of the permanent bar is if the person entered the United States without authorization, they remain in the United States in the aggregate for 1 year, and again, the starting time is April 1st, 1997, that person then, after a year in the aggregate, departs the United States, then attempts to re-enter or re-enters the United States without permission of the US government. Well, at that point, that person will have this permanent bar. And it's not like the government says, hey, you have this permanent bar, you can't get your residency. Most of the time, clients aren't aware, or consultations aren't aware of this permanent bar until it's too late. And unfortunately, we've seen these situations where the person comes to consult with us and we see the denial letter that was given to them at the interview, and it's because they have this permanent bar. Now, the permanent bar is a type of immigration violation, and this immigration violation does not have a waiver that you can file immediately to waive this permanent bar. In order to quote unquote cure this permanent bar, the person literally has to wait outside the United States for 10 years or longer, and we always recommend documenting the 10 years that the person has been outside the United States. Ways to document it would be tax documents, bank statements, working abroad, paycheck stubs, etc., to show that the person literally has been outside the United States for those 10 years. Now, after those 10 years pass, do not come back unlawfully, because then you'll start the clock again for this permanent bar. What you do is, if you're doing the immigrant visa, you hopefully by year 10, you already have your I-130 petition approved. You already have your interview ready to go. You go to the interview, and again, just kind of depending on the consulate and embassy. So we often deal a lot with the consulate in Ciudad Juarez. And so in that case, what often happens is with these permanent bars is they'll go to their interview, they'll get denied. Again, this is at the 10-year mark. They'll give them a sheet saying we're denying you for the permanent bar. And then at that point, after those 10 years, we can file what's called an I-212. And it's sort of a quote unquote waiver, where basically we are telling the government, here are the positive factors of this case, here are the negative factors of this case. We're asking you to please approve it so our client can proceed with their immigrant visa, their residency, and enter the United States lawfully. So permanent bar is a really big deal. If you are someone who has to travel outside the United States to get your residency, it's extremely important, especially if you've been detained by immigration, if you entered the border and were detained there. We, as attorneys, want to know that information. We want to request your immigration documents, what's called a FOIA, Freedom of Information Act, and see, did this person receive a removal order? Were they deported? Was it considered an expulsion or expedited removal, or was this person simply voluntarily returned? Because those are two separate things. And so very important, if you have to consular process, we want to make sure that you don't have the permanent bar, because again, if you travel abroad or you're abroad for this interview and you get denied, you have to wait those 10 years outside for the permanent bar. And we know that that is a very harsh law, and that affects a lot of family members, because if you have to be outside for 10 years and you weren't planning it, you've got your family here in the US, that becomes a very stressful situation. So again, if you need to go outside the United States to obtain your residency, very important to consult with an immigration attorney. Please tell us if you've been detained. We want to know that. The last thing we want is for someone to tell us we've only entered once, and then they go to their interview and it's discovered that they actually have a permanent bar. Now, another thing that we see come up during interviews is the smuggling charge. And so if you help someone come into the United States, you will get flagged generally with the smuggling charge. And there are some exceptions. If you helped your spouse, your child, or your parents into the United States, there is a waiver for that. Now, if you helped your neighbor, your aunt, uncle into the United States, unfortunately, there is no waiver for that, and that is a permanent denial. So that, again, is very important to tell us, to let us know, especially if, let's say, you were traveling with your uncle in this example and you guys got caught at the border. Very important to know what happened at that border, because again, they could potentially say, well, you know, you were helping your uncle, or maybe you said, well, yeah, I paid for him to come here. Those are going to be really big issues. Another very important situation that can lead to a permanent denial is a false claim to U.S. citizenship. there is a waiver that exists if the false claim was made before September 30th, 1996. On or after that date, there is no waiver. So if you went to the border and you presented a false, well, I take that back. You presented a birth certificate of a U.S. citizen, or you walked in and said, I'm a U.S. citizen, and you try to come into the United States, and they're like, wait a minute, you are going to have that permanent denial, unless this was said, again, before September 30th, 1996. It is a very, very harsh rule. Unfortunately, Congress hasn't changed anything on this rule, and it's a really unfortunate situation that sometimes people have to go through, unfortunately, where they didn't realize the implication of claiming to be a U.S. citizen. Other situations that we've seen is using a fake name or birth date at a border stop. We've seen, I would say, over the last couple of years, more misrepresentation denials on this case, on these types of cases, and I mostly see this with Central American clients. And what happens normally is, let's say a Central American client in the 90s, early 2000s, came to the United States, or tried to come to the United States, got detained at the border, and said, I'm so-and-so, I'm a Mexican citizen. And we know that sometimes people have said that so they don't get removed back to their home country, but simply get stopped and then get sent to Mexico, which is less of a trip compared to traveling back to the U.S. from Central America. And so now what we're seeing more is of these cases where that person, this was the situation for the person. We've laid it out at the application, or honest about, okay, yes, I was detained at the border and this happened. And so now their clients are getting flagged for misrepresentation for having done that. And so there is a waiver for misrepresentation. It's not easy. You have to have your spouse or parent and show that this family member will suffer extreme hardship without you, or will suffer extreme hardship if they have to travel abroad with you. So there is a misrepresentation waiver. Unfortunately, not everybody's going to qualify for it, because you do have to have that qualifying relative. So if that was you, or your loved one was in that situation, please consult with an immigration attorney, because these are things that we have seen and are seeing at the interviews at U.S. embassies and consulates. Another thing that we are seeing is if the person worked here in the United States with their tourist visa, or basically was living here with their tourist visa, and they go abroad for their interview, they are also getting flagged for misrepresentation. So with the tourist visa, remember, that is a non-immigrant intent. And so what you're telling the government when you're entering the U.S. is that you're just here on vacation. You're not here to work. And so if you enter with your tourist visa and you're actually working, government can flag you and say you misused your visa, you misrepresented yourself when you entered the border. Now you have this misrepresentation issue. Other situations would be a public charge. So when you apply for your immigrant visa, the petitioner, who's the U.S. citizen or the lawful permanent resident, they have to provide their tax returns. And the reason why is because the government wants to ensure that the person, the applicant, the one seeking the benefit, is not going to become a resident and all of a sudden start asking for public benefits. It's very important to have all those financial documents with you at the interview. If they believe that the petitioner has not earned enough, then they can deny the case. And then at that point, you need to find a joint sponsor potentially to show them that you are not going to be a public charge. So very important to make sure that the financial documents are in order before the interview. Now, other reasons why the case could be denied is, one, fraud on part of the United States citizen or lawful permanent resident. And this has happened where, let's say, dad, who's a lawful permanent resident, filed for son. It took 15 years for the son to finally get an appointment. Well, in that period of time, son got married. Dad's still lawful permanent resident. So technically that petition should have been denied because lawful permanent resident parent can't file for a married lawful permanent resident. But let's say U.S. Embassy or Consulate didn't catch it. Son didn't say anything at the interview. He gets issued his residency. Well, now he wants to file for his wife. I-130 gets approved. Somehow I didn't catch that mistake. Wife goes to the interview, and then at the interview it gets discovered that, hey, son should have never had that lawful permanent residency issued because he got married before he got married while dad was still a lawful permanent resident. And this does happen, unfortunately, and that is a very serious situation because now not only is wife denied, but now the son, who's / her husband, is now also in trouble because they should have never been issued that residency, and now they're at risk of losing that residency because they never should have had that residency. So again, very important when you're filing a petition for a family member, you need to make sure that everything, the way that the petitioner obtained their residency, was all done in a lawful manner. Otherwise, unfortunately, it'll have that domino effect where it'll affect not only the new applicant, but also the person who's the resident or maybe even the citizen. Other issues that we see at the embassies and consulates, I see this in Juarez a lot more often, is if the person was born, the U.S. petitioner was born in the United States with a midwife. And these can be very tricky situations. So in the 80s and 90s, there were midwives in border towns that would sign and say that X child was born in the United States, but literally the midwife had been paid by the family member, the parent, to sign this document. So document appears legit because, you know, midwife signs, yes, I helped deliver this baby was born here. There's an investigation, and then maybe it turns out that baby actually wasn't born here, and parent A paid that midwife. So when I have these situations where the client, the U.S. petitioner, was born by midwife, one, I ask a lot of questions. Two, I have them ask their parents a lot of questions because unfortunately there are situations where the parent will swear up and down that yes, the child was born here. They file that child files a petition for their spouse, and now at the consulate they're getting asked all these questions, and then at that point, you know, parent A confesses, okay, no, you were actually born in Mexico. These are really sad cases. So it's extremely important to, you know, if you were born by a midwife and you want to apply for your relative, you know, understand that very likely your case is going to get scrutinized. You also need to really talk to your relatives, your family members, verify that you were actually born here in the United States. And the other thing that we sometimes see is maybe you were born here in the United States, but sometimes the midwives, the issue that we've seen is the midwives, they did legitimate work. They birthed children here in the U.S., but they also committed fraud. And so then that's an issue because the government basically says, oh, this midwife committed fraud here, so now we're just going to assume that this midwife committed fraud for all cases, which isn't true. And so these cases can be very complicated. And what'll happen oftentimes is in Juarez, they want to question the U.S. citizen. They'll ask them about the birth. They'll even ask for the parents' contact information because they want to have that conversation with the parents and get the facts of, you know, where was this child born, who was present. And if anybody, if you have secondary evidence of I was baptized here, I went to get my vaccine shots here, everything needs to be documented. If you were born by a midwife, especially now with the passage of time, you want to collect these documents so you can have them handy, because other situations sometimes is the parent has passed away, relatives have also passed away, aunts and uncles, and now the person is stuck trying to prove to the government that, hey, I was actually born here in the United States. So these are delicate cases. The petitioner, the person seeking the benefit is generally going to be stuck abroad while the consulate sorts it out and determines whether this person was actually born in the US or not. And depending on the case and depending on the evidence, some people can be abroad maybe a few weeks, a month. Others, unfortunately, it'll be a lot longer than that. Other things that, other situations that we've seen is when a divorce has not been finalized or a marriage was not disclosed. So sometimes, and this is very important, if you got married abroad and let's say got divorced abroad, what are the rules in that country, and was it a recognized divorce? Because unfortunately there have been situations where the person paid the attorney abroad, was told, yes, your divorce was finalized, USCIS doesn't catch it, nothing gets caught until the person goes to the interview, and then lo and behold, oh, you were never actually divorced because X step, which is required in this country, was not completed. And so then that basically derails your entire case because you were never legally divorced, which means government cannot issue that immigrant visa. And so now we've got to start all over with the I-130 family petition. And the undisclosed marriage, we've seen that happen before, where someone's like, no, I've never gotten married. This is my first marriage. Great. And then client goes to the interview, and it is then found out that the petitioner actually had gotten married somewhere else. If you got married in another country, it counts as a marriage here in the United States. And that is something that people sometimes don't seem to understand. They're like, oh, I got married, in Mexico, that doesn't count. No, if you legally got married in Mexico, it is recognized as a marriage here in the United States. And those are things that we as attorneys also need to know. Again, we don't like these surprises because these cases take time, and everybody just, everybody wants that good outcome. And these are things that if we had known, we would have advised you, hey, this needs to get done before we start with the I-130 petition. So these are situations that we've seen. And if you have to travel abroad, like I said, to get that immigrant visa, it's extremely important to know, what are your rights, what can go wrong, why is it that something can go wrong. And if you have any questions, consult with an immigration attorney. We see these things, and these are things that we want people to be prepared and make sure that, hopefully there aren't any errors that will delay your case or will cause a permanent denial. Or if there is that situation where your case is going to get permanently denied, well, we want you to be aware of that before you go to the interview and get permanently denied. The other last thing that I will talk about is administrative processing. I've seen this in a variety of cases. Administrative processing doesn't necessarily mean that there's something wrong with your case. Generally, it means the government needs to run some more background checks before they finalize the case. Now, I've seen administrative processing for cases for a variety of reasons. Sometimes clients can be in admin processing if they think, oh, well, so-and-so's relative was, arrested or convicted for drug trafficking. And let's say this was a brother-in-law. I've seen that situation where the person was placed in admin processing for a few months while the government did these background checks. I've had other cases where someone with DACA got placed in admin processing. There was no rhyme or reason, just simply told your case was placed in admin processing. Others who had tattoos, and they put them in admin processing and they were out for about a month. So admin processing, it really sucks when your case gets placed in that process. Sometimes it can be as quick as a day, a few weeks, maybe a month, but other cases, unfortunately, if the case gets placed in admin processing, it can take 6 months or longer to get a decision. Now, if you're reaching those 6 months at that point, I would recommend discussing suing the government in order to try to get a decision from them. So these are some of the this is some of the information I wanted to share in terms of what we've seen when clients go to the interview abroad at the U.S. Embassy or consulate. Unfortunately, we, the attorneys, cannot go into the interview with the client. So it's a very stressful, nerve-wracking situation for clients, and we always want them to be fully prepared and aware of what to expect and why a case could go wrong. So thank you everyone for your time. And if you would like to consult with your office, you can call us at 972-827-8359. Thank you, everyone.